Assemblymember Dixon, did you have a question?
Yes, just to follow up to all of this, just to kind of clarify my frustration and my astonishment about the lack of people understanding. Let me focus on the Board of Governors for a moment. My understanding in reading the investigative report is that Mr. Miller was a law partner of Mr. Girardi. Is that correct? So for
Yes.
issue number one, conflict. Question number two, what is the role of the Board of Governors in understanding I'm sure, like all boards, whether it's a board of directors or a board of governors or board of trustees, there's an executive director report at every board meeting that gives a report of in this case, in your case, in the past, in your predecessor, the number of complaints against lawyers, the number of misfilings. Was that done under the, I guess, current? I don't know if the entire board has changed over. Are there current members of the Board of Governors that are still on, serving out their term that were during this period of time?
If I may, Mr. Chair.
Mr. Durand, go ahead.
Yes, so the Board of Trustees, 13 members, all now appointed, as I mentioned, by the various appointing authorities. We do have 2 of our members who were subsequently appointed by the Supreme Court, having been, I believe, elected under that prior, and I stand to be corrected if I've mistaken Mr. Broughton and Mr. Stallings. But otherwise, that election era process is gone.
Okay, so under the new procedures, which I hope have been implemented,
Yeah.
I mean, just on the basis of the LA Times coverage of this, you knew there were a lot of things to fix.
Certainly.
But I would think it'd be fundamental in terms of the bylaws of the organization or rules of procedure that these kind of staff operating statistics data, performance data, would be routinely every meeting reported to the board. So knowing that a former law partner or current law partner of Mr. Girardi was on the board at the same time these complaints were filed, were there red flags?
Yes, I mean, there certainly should have been. And I think Mr. May's report tells us that they just weren't raised well enough in the way that you've described, certainly. If that were the case today, most certainly red flags would be raised and
because it just leads to what my colleague to my right was saying, that there has to be accountability, process, and procedures, and maybe there is a cultural intimidation factor that the staff did not want to challenge or surface red flag behavior activities that members of the Board of Governors, the trustees were performing. I mean, my recommendation is we can allay a lot of this frustration is going forward. It shouldn't take legislative action to say, get this house in order quickly, because there's been, as Mr. Seeley was saying, potentially criminal activity that was going on between Mr. Dunn and the organization and Mr. Girardi. It is a cover-up, as my colleague said. I mean, are we even going to get to this? How do we know we're going to remedy the cover-up, as well as going forward under new management? That's great. I do want to make a comment. We're all public officials elected, whether elected or appointed. In many cases, we all are familiar with Form 700s. We all do it. Why is this so hard to administer and report on and tabulate Form 700s? I mean, on local city planning commissions, they fill out Form 700s. It's not rocket science. So I just hope, just to follow up on Assemblymember Ray's comment, that we could get that minor procedure, but that's a very commonplace procedure with anyone serving in a public role, to get that situation cleared up. Okay, thank you very much.
Let me ask the panel who would like to respond to that.
I think I would like to, because I'm sorry if I misrepresented something, or I agree that exchange was confusing. I do see myself as accountable for completion of the Form 700 and for completion of what we call the 2201 conflict checks. There's 2 processes internally. One is that Form 700 that you're very familiar with. One is internal to the State Bar. This is identification of conflicts. For example, my family member who's a lawyer, I have to identify that. that I am responsible for that. I do not, the way the State Bar is structured, I do not supervise the Chief Trial Counsel. The Chief Trial Counsel has indicated that he's established his own internal policy for an additional level of conflict identification when a case is opened and when it's closed. He's responsible for making sure that his staff comply with that. In all instances, if a staff member fails to comply, and obviously we have to provide due process, but there are remedies that include employment-related remedies. And in that instance, whether it's an OCTC staff member or someone else in the State Bar, I, working with the Office of General Counsel, would deal with effectuation of those personnel remedies. So I want to be clear about that. I'm perfectly willing and think it's appropriate to take responsibility, not trying not to. I think what you're hearing is we do work well as a team, and it is a complex organization, and the leadership structure of the organization is complicated. You have the 3 reports to the board here speaking to you, and we work together, and I think we work together well, but sometimes you might see us stumbling a bit as you did earlier. But I do want to make it clear that I take the responsibility on willingly.
And all right, thank you. Did you want to further respond, Mr. Duran?
I'll let Mr. Cardona go, Mr. Chair.
All right.
Just going to respond to your question about kind of accountability to the board and reporting to them on cases. That is something we do. You heard Mr. Duran refer to the disciplinary liaisons, who are 2 board members who are appointed as liaisons to the disciplinary system, to OCTC. I meet with them on a regular basis to keep them advised of our caseloads, how those caseloads are working. And then we do reports to the board as a whole on our metrics and statistics and how our cases are being handled. Some of that is occasionally in closed session where we discuss particular cases, and then in open session, the broader view of how the system is working.
There's just one follow-up question to that. So do you anticipate a cultural problem if the president of the Board of Trustees, in this case it was Mr. Miller, and he's a law partner of Mr. Girardi, how would you deal with that?
I would have no problem with that because, as Ms. Wilson has indicated, I don't answer to the executive director or the president of the bar. I answer directly to the board, and I would go to board members who were not that conflicted board member and report whatever I saw. You also heard reference to the new whistleblower program that's been put in place. That's precisely to address that type of situation, to ensure that we have an outside avenue to allow employees within the bar to report conduct by higher up who they might not feel comfortable reporting to those higher ups. So that's something new that was just approved by the board in response to some of the recommendations in the May report. But I think that's a very important thing to ensure, for example, one of the examples that the May report cited was an instance where there were OCTC employees who were recommending action against Girardi, but they were overruled and ultimately fired. That couldn't happen now. If that happened, a complaint could be made to this outside agency to investigate what would be a traditional whistleblower or whistleblower retaliation complaint.
So they were fired by Mr. Dunn, if
Yes.
I've read the
Well, yes, according to the May report.
And did the board know of that?
I assume that the board had to have known of it since the action was taken, and it wasn't concealed action. But again, I wasn't there. I don't know precisely who knew what.
Okay. All right. Thank you very much. Appreciate it.
Thank you, Assemblymember Dixon.